a warm welcome. You're watching Viewpoint with me, Grihatul Siddiqui. The Supreme Court will begin hearing petitions challenging the changes to Article 370 and downgrading of Jammu and Kashmir state into two union territories on August 2nd. Earlier, the centre had told the Supreme Court in its affidavit that they have quote-unquote brought unprecedented development, progress and security and stability to the region, often missing during the old Article 370 regime. The Chief Justice of India, D.Y. Chandrachud, however, has said that this affidavit would not have any bearing and shall not be relied upon on deciding on the constitutional issues raised in the petitions. It has been argued that since President's rule in the state is an interim arrangement until an elected government is put in place, the administration under President's rule cannot take decisions that change the very constitutional structure of the state. As for the downgrading to union territory, remember there is no other instance in Indian constitutional history so far of a state being demoted to a union territory, even though Parliament can, under Article 3, create a new state by carving out territory from any other state, uniting two or more states or portions of different states. Thereby, the centre's decision has been challenged on the ground that it is violative of Article 3. It has been argued that under President's rule, only those powers of a state legislature can be exercised as are essential to run the day-to-day affairs of the state. And last but not the least is the challenge based on the argument that the constitutional changes are colorable legislation, which essentially means that it cannot be done directly and it cannot be done indirectly.
जैसे 2019 से पहले कोई टूरिस्ट जम्मू कश्मीर आया ही नहीं, जैसे इससे पहले जम्मू कश्मीर में कभी कोई अमन था ही नहीं। इस चीज का भी जवाब दो कि वो नए इलाके कैसे मिलिटेंसी के शिकार हुए।
The very basis of the relationship of people of Jammu and Kashmir with the Union of India has been questioned. The relationship itself has been derailed.
Let's now first get you a memory jog on what exactly has led to this abrogation of Article 370. Let's take a look at what are the principles that have been put in place to abrogate the Article 370 and the autonomous status that's been granted to the erstwhile state of Jammu and Kashmir. Now, what has the government done? The government has went about using Section 3 of the Article 370 to nullify the article altogether. Now, basically, the Clause 3 of Article 370 empowered the President of the country to declare that this Article 370 shall cease to be operative completely or partially, but only if the Constituent Assembly of Jammu and Kashmir recommended such an action. Now, secondly, the revocation needed a constitutional amendment. Like I mentioned, and Section 3 gives the President that power to revoke the article. The revocation, in fact, was a recommendation. It was via that recommendation of the Constituent Assembly. Now, the Constituent Assembly was, remember, dissolved on January 26, 1957. That was what the argument was, that since the Constituent Assembly of Jammu and Kashmir no longer existed, having dispersed in 1957, this power of the President had ceased unless a new Constituent Assembly came into being. Now, looking at the other point, Governor's rule, in fact, vested all the powers of legislature with the Parliament. Remember, the Governor's rule was imposed in Jammu and Kashmir on June 19, 2018, after the BJP withdrew support to the coalition government that was led by the Chief Minister Mehbooba Mufti. Now, under Article 92 of the Jammu and Kashmir Constitution, 6 months of Governor's rule was mandatory before the state could be put under President's rule. Now, with the Parliament in session, the government legally was bound to announce this particular move, and this is what exactly happened. In fact, the presidential order was revoked and it went on to revoke Article 370 via the parliamentary consent that was given. It was on August 6th that the President ruled. In fact, the President issued a declaration under Article 370 Clause 3, making all its clauses inoperative except the provision that all the articles of the Constitution shall now apply to the state, the then state of Jammu and Kashmir. Now let's further take a look at what do the petitioners contend and what is it that the petitions really have as far as the pleas against the abrogation of Article 370. Point number one that we are looking at is that the petitioners are claiming that the abrogation of Article 370 is completely unconstitutional, it is void and inoperative. That's point number one. It is argued that the state government meant the Maharaja, which was later changed to Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of the Council of Ministers. But considering there was no state government either in Jammu and Kashmir, so the President had no way to acquire the concurrence of the state government. That's a major argument against the entire abrogation of Article 370. Clause 3 of Article 370 prohibits the revocation without a constituent assembly. That's the main argument, and hence they are claiming that this is an unconstitutional arrangement. Presidential order is subject to the constitutional scrutiny, which was not done, as is being claimed through the process of these pleas. The Parliament does not have the power to downgrade the states. Something that I mentioned, they go on to say that's violative of Article 3. The Parliament cannot go ahead and downgrade a state to union territories. This has never been done in Indian history. Talking about delimitation exercise, they also go on to argue that that is violative of the right to equality. So one fundamental right has been put into play as part of these pleas. The right to autonomous self-government is a fundamental right. That's another fundamental right that has been actually presented by way of the pleas against the abrogation of Article 370. Then we also go on to have it from the petitioners that the abrogation defeats the entire principle of the pluralistic federalism that India in fact stands for. And that's why they are in fact denouncing the abrogation altogether. They also lastly go on to say that overnight abrogation of Article 370 was a challenge to the democratic rights, which are in fact guaranteed, and that guarantee was given post the accession of Jammu and Kashmir into India. Now, before we go further into the debate and we open it up on the broadcast, let me first bring in Mr. Yusuf Tarigami, who's the leader of Jammu and Kashmir unit of the CPM, and he's also petitioner in this particular case, and he's joining me this evening. Mr. Tarigami, thank you so much for being a part of this conversation. I'd first like to begin by understanding what are the main arguments that you have presented before the Supreme Court as part of your plea.
Our major concern has been and continues to be the assault on the constitutional rights of the people of Jammu, Kashmir and Ladakh. And we have prayed before the Supreme Court that whatever has been done on 5th, 6th August 2019 is not only contrary to the constitutional procedure, but constitutional spirit as well. It is virtually something which distorts the whole constitutional order, is a guide for our country, which we have achieved through a protracted struggle for independence, which we have been given after due deliberations in the Constituent Assembly of India. And that's what has been assaulted, distorted. So that is why how we have approached the Honorable Supreme Court, because there is no other remedy available for us. This is the opportunity which we as citizens have decided to avail of.
Actually saying that the centre's decision is violative of Article 3 of the Constitution to downgrade the state into union territories now. Is that what your essential argument is?
You see, our position is that, the circumstances in which the country got divided and accession of Jammu and Kashmir took place on 26th October 1947. Though ordinarily it should have happened on 15th August, but it did not till the tribals, raiders from across invaded us here. And finally, the Maharaja, who was the chief vice of Jammu and Kashmir at that point of time and authorized to accede to either of the domains. So he was reluctant on 26 October till the invasion took place, and he sought military intervention support from the Union government, and it is how the instrument of accession was signed by Maharaja, and Jammu and Kashmir acceded to India. And this is one part of it. And then the another part is, at that time, Constituent Assembly was in session, and it started its deliberations after some time. And then the constitutional frame was being discussed for the whole of the country, including Jammu and Kashmir. And this was during those deliberations that Article 370 emerged, became part of the Constitution of India. And so our point of view is, it was not a danger at that time, rather inclusion of Article 370 with certain guarantees to the people of Jammu and Kashmir, certain assurances, certain promises, constitutional promises were made. And it is in that context that the accession took place and was ratified, and the attempts from the other side of the border were defeated. So my point is that we must understand the context, and we must understand the validity of this article. Was it ever hurdle for our relationship with the Indian Union? Rather, it facilitated the relationship. It was the article of the Constitution of India, which evolved itself through a discussion, proper discussion in the Constituent Assembly of India itself.
So essentially, Mr. Tarigami, I wanted to understand, over the clutch of petitions that suggest that Jammu and Kashmir Legislative Assembly wasn't legally competent to give assent and consent to the presidential order, what are your views on those petitions?
There are two issues are there. First issue is, now they are talking about that this was a temporary provision. This was a temporary provision, article, part of the Constitution of India. And you look at it, the whole clause, whole article, you will find out there are certain provisions, certain clauses, which suggest that President of India can, through the order of the President, this provision, this article can be removed, but only with the consent and approval of the Constituent Assembly of Jammu and Kashmir.
Right.
It's not the Assembly of Jammu and Kashmir, it is the constitutional authority of Jammu and Kashmir, Constituent Assembly of Jammu and Kashmir. You please open it up and read it out and go through it and then tell us why the violation has taken place. That is why our opinion is that at one point when the Constituent Assembly was in session in Jammu and Kashmir, that Constituent Assembly ratified the accession. And we have claimed that now it is the final verdict of the people of Jammu and Kashmir in favor of accession of Jammu and Kashmir with the Union of India. And on the other hand, the same Constituent Assembly has not asked for revocation, abrogation, removal of Article 370 till its conclusion. So where was the necessity of, that means what? That means the precondition for removing the Article 370 was approval or any recommendation from the Constituent Assembly of Jammu and Kashmir. That has not been done. That means it has become permanent. There is no authority, not even the Parliament of India, which can remove the clause in absence of the Constituent Assembly of Jammu and Kashmir. That's how the constitutional order stands.
All right. Thank you so much for sharing your views, Mr. Tariq Ami. Appreciate you joining us on the broadcast. And on that note, let me now open this up to my panel who's joining me this evening. Tuhin Sinha of the BJP, Ahmed Ayaz, who's a political analyst, Kapil Sankla, who's a lawyer, Farooq Renzu Shah, who's the former Jammu and Kashmir bureaucrat, and also joining us is Muzaffar Khan of the National Conference. Good evening, gentlemen. And let me begin with you, Tuhin, considering BJP is the target of the petitions that are going to be making a part of that beeline to the Supreme Court. I wanted to understand the principal argument that's being made through the series of these clutch of petitions is that this entire abrogation was completely unconstitutional. How does the BJP choose to respond to it?
Well, good evening, Priya. Good evening, everybody. In fact, it was Article 370 which throughout bordered on unconstitutionality. It impinged upon Article 15, which ensured equal rights to all citizens. A large chunk, a significant chunk of the population of Kashmir, and that included refugees from Western Pakistan, that included Dalits, that included Sikhs, that included Gorkhas. Even after 70 years, they were denied basic voting rights or access to government jobs. So in the first place, it was Article 370, which was unconstitutional, that had to be removed long ago. Now, as you yourself mentioned, Section 3 within Article 370 gives the government that power. Now, when it comes to taking the Constituent Assembly, in a case where the Constituent Assembly is in limbo, it does not exist, there is no specification whether, the central government cannot do the needful insofar as implementing the abrogation is concerned. I would like to take you back into history. In fact, the Constituent Assembly of Jammu Kashmir was set up in 1951. It was the responsibility of that Constituent Assembly to take a final call on Article 370 because as per our constitution, it was always supposed to be a temporary provision. But that Constituent Assembly of Jammu and Kashmir was dissolved suddenly and abruptly in January 1957 without taking a final call. So essentially, Article 370, by virtue of employing Clause 3, Section 3, the central government had full right to take a call on application of Article 370, which is what we have done.
Okay. Now, let me actually bring in a member of the National Conference here on the broadcast. Mr. Muzaffar Khan, would you like to respond to the arguments that the BJP is essentially making? Tuhin Sinha says that what should have been done as part of the Constituent Assembly that was bizarrely and abruptly, in fact, dissolved in 57, that is something that was an unfinished task that we undertook as the government at the centre, which was long desired and should have been done in the past. Your views?
It is totally wrong that it was dissolved abruptly. Basically, they finished their task of framing a constitution which will govern the relationship of central government with the state of Jammu and Kashmir. And dissolution of the Constituent Assembly marks the permanence of Article 370 because at that time, when our Constituent Assembly, it got elected, unlike the Constituent Assembly of India, which framed the Indian Constitution, which was not an elected body, our Constituent Assembly was elected for a fixed term and for a fixed purpose. The purpose of that Constituent Assembly was to draft a constitution of Jammu and Kashmir. They drafted the constitution of Jammu and Kashmir, leaving it that whatever conditions contained in Article 370, which was adopted by the Constituent Assembly, which framed the Indian Constitution, after a fact-based discussion and debates, will govern the relationship between state and union government. So that was, in a way, finality to the Article 370, removing that doubt of permanence. Secondly, Honorable Supreme Court after that, in very famous case of Sampath Prakash, who died very recently. In his case, the Supreme Court came to the conclusion that it is no more temporary. So that is an argument which we are going to project before the Supreme Court in our petitions also. But that was the Supreme Court Constitutional Bench's conclusion that after dissolution of the assembly, it has assumed the permanence. Secondly, the way it has been abrogated or made inoperational was totally unknown to the canons of the constitutional history of any country. You introduced a parenthetical clause in Article 367 by saying that World Constitute Assembly in Article 370 shall be construed as legislative assembly, which legislative assembly was again not in existence because it was already dissolved. Governor rule were there initially for 6 months, and after 6 months it was the president rule. So the president is asking governor to give his assent in terms of clause 3 of Article 370, which ultimately means that the office of the president is giving consent to itself. So that again is totally unknown, a procedure which is not known in the history of a democratic society. Second thing is that it has not only touched the basic structure of the constitution, which is the federalism, as in Bomey's case, the Honorable Supreme Court, Constitutional Bench of the Honorable Supreme Court has held that federal structure of our constitution is a basic feature of the constitution. So this federal structure, which was guided by Article 370, like many other states, if you will have a look at Article 371, similar provisions are contained for many other states. So with this, that the federation will cohesively work together.
Okay. Let me actually bring in Kapil Sankla on this. Kapil, I want an honest legal perspective, because this will get complicated if not understood properly. I want to understand in layman's language, do you think that the loopholes that remained as far as Article 370, which were used by the BJP government in power, in fact was something that led to this entire abrogation? And in that process, if we take a look at the petitions, considering on paper, Article 370 remains, the changes have been made to 371 of the article. So how does one read that vis-a-vis the abrogation?
Always honest, as honest a lawyer can be. You see, the background is very important here.
Yes, absolutely.
Both my learned friends have made some statements. I think there are some inaccuracies in that, and I'd like to cover that. First of all, is this that the timelines are very important. You see that in 1947, this instrument was signed, granting special status, etc., etc. At that time, the Constitution of India wasn't made. It wasn't created, it was being written. In 1949, when the Constitution of India came, it actually took that instrument, made it under 370. And it was clearly something that wasn't there to be forever. It was temporary. My friends have also said that this was in part 3. And part 3 is very important because everything that moves under Article 370, part 3, which says, notwithstanding anything in the foregoing provisions of this article, President may by public notification declare this article shall cease to be operative or shall be operative only at such exception. So therefore the right was there. The intention was that someday to say that, all right, 370 goes, whatever, and then now Jammu Kashmir becomes a part of India. That intention was already there. How this is also seen is also in the Constitution of India. The part 1 of the Constitution, which is the Article 1, itself says of the Indian Constitution that Jammu and Kashmir is the state of India. So that clarity was there in the Constitution itself.
Yeah.
And then thereafter came, as one of my panelists has said, Article 35A was introduced subsequently, I think somewhere in 1954, which also kind of is also precedent in the sense that there were certain amendments made. 35 also gave certain rights to Kashmiris, saying that, the right to purchase land would be exclusive. But what is important is that in 35A itself, which is a part of, and also the Jammu Kashmir Constitution itself says that Jammu Kashmir is an integral part of India. So once that is there, there is no other argument that is required to be made in any eventuality. But if made, then what is important to see is that there have been number of other presidential orders which basically mean that there have been binding precedents which have been accepted by all the parties and all the stakeholders here. In fact, you would be surprised to know that there have been 47 presidential orders similarly placed between 11 February 1956 and 19 February 1994. In all of them, and those have been upheld by the Honorable Supreme Court in 1972. And in all of them, the Constituent Assembly wasn't there. There was no Constituent Assembly. So therefore, this argument that is being made today is in the teeth of something that has already happened, already accepted, already gone to the Honorable Supreme Court, and the Honorable Supreme Court already giving its stamp of validity to that. Now, in this case, in this particular case, what had happened? What had happened was that once the presidential rule came to be and the federal rule, so to say, came to be, it was within the ambit and the power of the president to pass an order under Article Subclause 3, which was duly passed. Now, that is being tested, I do understand. But we also have to understand two material parts. In fact, three material parts. The Constitution of India says that this would be a temporary provision. Article 1 clarifies that Jammu Kashmir is a state of India. The Jammu Kashmir Constitution says that it is an integral part of India. Now, after that, unless they are saying that we do not believe in Indian Constitution or the Jammu Kashmir Constitution as it was, I don't think there is any other argument that is required to be made. And now, lastly, what has happened? Now, because of that, you would understand that there was right to information. There were rights given to women as far as property is concerned. All of that was applicable all over India except Jammu Kashmir. Now, an equal playing field has been created. All those protective rights to women, to children, POCSO rights, right to women to inherit property, RTI rights, all of that have been given to the common citizen. So when you look at the larger canvas...
That's an important point to make, Mr. Thankla, but I still want to understand the pleas that have been presented by way of the argument of fundamental rights. How much of that would be binding on the Supreme Court and would have any kind of merit as far as the petitions that the Supreme Court is looking at?
You see, the short answer, as I said, was that since there are binding precedents that have been ratified by the Honorable Supreme Court, those arguments to be made today might actually be a difficult argument before the Supreme Court without first challenging the order of the Honorable Supreme Court made way back in 1972 and also challenging more than 47 presidential similarly situated orders that had been made. So therefore, the short answer to your question is, since there are binding precedents, without going into the merit of the fact, unless those binding precedents are challenged, that order is a good order for the Honorable Supreme Court today.
All right. Let me actually bring in more of the political angle. Ahmed Ayaz, I'd like to understand the statement that came from the PDP. Mehbooba Mufti, in fact, ended up challenging the Supreme Court in a statement. She was worried that why is the Supreme Court looking at these clutch of petitions after 4 years? What really got this upon the Supreme Court? And that is something that she's more worried about. As a political analyst and as somebody who's looked at the politics in the state of Jammu and Kashmir, in now Union Territory of Jammu and Kashmir, one of the very crucial aspects of the country, do you think that is a logical argument to make? Mr. Ahmed Ayaz. Mr. Ayaz, are you able to hear me? I think you are on mute. Yes.
You see, as long as the comment or the statement made by someone, I think everybody is within the rights to talk about the issues which are concerning the state or the country. So if the Mehbooba Mufti has done the same, to that extent she is justified in her own way. But to say that there is some politics involved, I don't think that at this stage I can say that we can't say that the Supreme Court and the courts have been politicized and they have taken that view. Yes, courts may have their own compulsions, they may have their own agendas, they may have their own programs, they may have their own calendars. But to say that they are politicized, I don't think that would be fair to say. Well, it is after say delay, which we can say it is delayed. Why? Because abrogated a lot of things have happened. One is that the special status with the Jammu and Kashmir, the permanent residents of the Jammu and Kashmir were enjoying, that has been removed. And then there had been the 35A also removed, which by virtue of which the residents of the Jammu and Kashmir were enjoying a job and land rights. and then thereafter the state was bifurcated.
Okay.
And bifurcated in parts, like Ladakh, a separate union territory, and then the Jammu and Kashmir, another one. And then the fourth doing, it was state was downgraded, what you call it, union territory. Because first of its kind, this has never happened. Normally we said that the duties are upgraded and then made the states. But here we say that the state, a very, very princely state and a very historical state has been, downgraded and bifurcated. Well, there are points which needed immediate consideration of the Supreme Court. And if they are not done it, that we cannot now question as to why they haven't done it, there's no reason. But anybody can feel so as to why it has been delayed. But to say that there is something politics involved, we can't say that there is a political influence on the courts. I don't say that.
Okay, let's go back to the petitions. Let's go back to the petitions. Mr. Farooq Shah, I'd like your word on it. You've been patiently waiting. I'd like to understand the two important petitioners in the name of Mr. Shah Faisal and the other petitioner, Sheila Rashid, also wanted to rescind themselves from the list of petitioners. They no longer want to be a part of the petitioners who were in fact seeking to understand the constitutional validity of the abrogation of Article 370. Do you think that in fact will weaken the case of the petitioners or the 21 clutch of petitions that are already there with the court?
No, that is the point. I know Shah Faisal very well. I was myself in the affairs at the time when Shah Faisal joined the administration. Even when he was playing with the idea of joining the politics, I met him at the Gulmarg. I told him, you are doing a foolish act. What are you doing? Don't join this nonsense of politics, because what exactly has happened to Kashmir is we have been spoiled by the political conspiracy. 1947 was the two dynasties who really made a Kashmir for a perpetual rule of the dynasties, one dynasty in J&K and another dynasty in the center. So that they play with this football. First they divided our Kashmir. Baltistan hamara hai, that is ours. The Gilgit is ours. The Shahra Ibrahim, which you called China-Pakistan corridor, you wrongly call it.
Okay.
And presently, big leaders call it. Neither it is fathers and grandfathers territory of China, nor it is the fathers and grandfathers territory of Pakistan. It basically, this should not have been divided. And when agreement and the instrument of accession was signed, the map is enclosed. That map is up to the Chitral border, up to the Khanjri Pass, up to the Durand line, up to this, all these vital places were ours, and how it has been left to them. Why at Uri, who halted the advancing army at the Uri, is a big conspiracy. And then another conspiracy was a simple presidential ordinance. If they would have been the serious of the same 370, they call it. If both of them would have been serious, then it would have been justified, certified, endorsed by the parliament by unanimous vote when there was an agreement. What was the Delhi agreement?
I'd like a quick word from Tuhin Sinha on this. One second, Mr. Shah, I really don't have time on the broadcast because I have to go to some breaking news. Tuhin, the fact that the Supreme Court of the country has also said the argument, the affidavit that has been presented by the Solicitor General that there has been development in the state after the abrogation will not have any bearing on these clutch of petitions. How do you respond to that?
Well, first of all, let me call the bluff of the two regional parties, the National Conference and PDP. One of the biggest and the most brazen myths promoted by them was that Articles 370 and 35A are linked to Kashmir's accession to India, which is not true at all. The instrument of accession which Kashmir had signed is similar to 500 other princely states that they have signed the same. It does not mention that Article 370 had to be. The Article 35A was brought in 7 years after Kashmir's accession in 1954, and that too through an act of ordinance which was entirely unnecessary. So I think these articles had to go. They should have gone after 1971 war, where India was in a position of vantage. but we let that opportunity go. These articles had reduced Kashmir to a ghetto. Kashmir, mind you, was never a closed ghetto. It was always a land of free trade with Central Asia way back, even 1,000 years back. But these articles had taken Kashmir many decades back, and it is about time these articles had to be removed. I'm sure the legal experts on our side would explain the legal nuances better. But the government, as I had mentioned in my opening remarks, has employed sections and clauses which were inherent to the removal, which were very much there, contained over there, and it is absolutely a constitutional act of removing it, of abrogating it.
All right. Thank you so much. I'd like to thank all my guests who are joining us on the broadcast this evening. That's all the time that I had. We'd have to actually wait for the Supreme Court now to hear those bunch of petitions that are against the abrogation of Article 370, and let's see if it stands the test of time. With that, I'm slipping into a very short break, and up next, the murder of a Jain monk has sparked a political storm in Karnataka. Who is stoking the tensions on the ground is the big question that we are asking on the other side of this very short break.